Good morning, everyone. Welcome to the third and final day of the conference. My name is Arsineh Arakel, and I serve on the board of directors with the Center for Truth and Justice. On behalf of our organization, it has been a pleasure meeting all of you this week and learning from you over the past few days. We are excited to present another great day of panels, starting with the mornings for the presentation, which is sure to be excellent. Today, I am honored to present to you someone who has one of the most challenging positions in this country. Yeghishe Kirakosyan holds the distinguished position as Armenia's representative before the European Court of Human Rights. In addition to his work at the ECHR, in 2021, Yeghishe led Armenia to the International Court of Justice for the first time in the Republic's history. There, his legal team successfully obtained provisional measures from the court against Azerbaijan. And now they continue to monitor and present evidence to the court of Azerbaijan's ongoing violations. Yeghishe has worked closely with the Armenian government since 2008 as assistants to the prime minister and later to the deputy minister of justice. He has been teaching classes here at AUA since 2011 in international law and the international courts and on arbitration. With that being said, Mr. Kirakosyan, we would like to present to you and recognize you for your distinguished contributions to the Armenian nation. Your dedication and work for this country deserves the utmost recognition.
Thank you. Thank you for this honor, and thank you for giving the opportunity to speak during this high-level and distinguished conference. And first of all, I'd like to thank the CFTJ team for putting together this conference. I think this is an incredible work. Thank you, Gasya, and thank you, team. This has been, I know that how demanding putting together a conference is, and done myself 10 years ago when I was starting an NGO myself in 2010. And I think this is the maybe best timing to start discussing issues relating to justice, relating to accountability and reparations, because we are in a way of have already triggered many international legal mechanisms that are running already, and we need to be very united maybe and very attentive in pursuing this path. And of course, this conference also is an opportunity to hear different voices, not only from Armenian world, which is important to talk to each other, to present the ideas and views, but also to present the opportunity for foreigners, for experts and high-level experts and highly qualified publicist people to start also getting known the cause that we're fighting for, and also to get them acquainted with the ideas and the main purpose that what we're doing, because that's very important. Just my job as a representative before the European Court of Human Rights, I started when I was appointed in 2018 as representative and agent before the European Court of Human Rights. I was dealing at first only with the cases before the European Court of Human Rights with individual applications. But of course, long ago, when I was still in a government back in 2008 and 2010s, I had always pursued and try to promote the idea that Armenia should be very active in using international legal tools and including international courts, international tribunals to pursue foreign policy agenda. Because I believe as an international lawyer, trained international lawyer, that those are important tools for Armenia as a country, as a sovereign country, to put there and to use those and to promote its position and interests in the world globally. And it has been a long road, and unfortunately the events that triggered the use of such mechanisms were not were very painful events. I think that's maybe natural, although it's unfortunate, but that's natural because those painful events are the triggers and are the sobering events that gives the nation a kind of an earthquake. Some sobering moments when you realize that there is nothing more to lose. And I think the 44-day war was like that. And in the course of the war, and when the war started from the very first day, we started to use the European Court of Human Rights toolkit and mechanism to try to, although maybe it was too idealistic to do that, but we initially thought that I think we need to act in a way. We started to use the toolkit provided by the European Court of Human Rights, the toolkit, the interim measure request or interim measure procedure that the court has. And we applied right away on the first day of the war, on 27th of September, and asking the court to order Azerbaijan to abide by the rules of the convention and not to target civilian populations, civilian objects, and civilians settlements, etc. And we got the order, of course, in 2 days later. And then we started to work closely later on as the evidence was coming out and social media circulating relating to the POWs, relating to captives, Armenian ethnic captives, being tortured, being mistreated, being also the executions, the arbitrary executions and sceneries of war crime, cutting throats, heads, and of civilians fallen under the control of Azerbaijani soldiers, the horrible videos that were circulating in the social media. And of course, those the work has been actually non-stop since then. And we also were initiated legal tools of the same court, European Court of Human Rights, against Turkey, because we had the evidentiary measures, evidentiary means since the beginning of the war. It was well being circulated in reputable international media that mercenaries were being used and financed and transported by Turkey being used in a conflict zone. So we also applied for an interim measure against Turkey, which was granted too. And this has been, of course, a kind of a drop in the ocean, maybe, in a way, because you imagine you all know what happened, I think, during this 44-day war. I think the armed activities and the crimes committed and the escalations happening every day, and doing this legal job, maybe it sounded a little bit not adequate, and many, I think, started doubting, and a lot of people were asking, why are we doing this? And even after that, even after the end of the war, when we continued pursuing this path, when we submitted the interstate application, the full applications, triggering an interstate proceedings before the European Court of Human Rights, both against Azerbaijan and Turkey, and most of people were asking and doubting, were skeptical, asking, why are we doing that? Does it have an effect? In any case, Azerbaijan is not abiding by that. They don't care. Turkey doesn't care. They have the resources. They can buy anyone. They can buy the judges. They can buy the courts. They can buy the international, influencers and make it as they want. Yes, that's right. That's correct. But why is that the case? Why that happens today? Why it is the reality that we live today? I think that's simple because today's international law and today's international relations changed dramatically, and they continue to change. I think due to the tectonic changes that we have in globally, because we do have this the digital era where the information is spreading within a matter of seconds, and it's became quite really easy, relatively easy to manipulate and to impact, to influence people. And in the end of the day, what Azerbaijan has been doing actually before the war, that also important to note, because what happened before the war, I mean not the days before or months before, I mean decades before the war, or decades preceding the war. What happened before that? What was going on? I'll tell you what was going on. I'll try to put it in very short summary so that we have a picture what's happening, what was happening before that. Starting maybe around 2006 and 7, when I think it's right a couple of years after Aliyev came to power, Ilham Aliyev came to power, Azerbaijan's policies relating to using international legal toolkit, also relying on international law, has been, I think, re-emphasized. What they have been doing the following. They've been engaging in the following policies. They have been engaging a lot of prominent scholars and commissioning reports to promote the narrative that they needed. Narrative relating to use of force, or legality of use of force, or narrative relating to the right to belated self-defense, and narrative relating to Typosidetis, or title to territory. Narratives relating to Armenia being an aggressor, and narratives that discarded the legality of Artsakh whatsoever. And the names who authored this report are well known. I'm sure that most of the international legal community people will know them. British scholars, French scholars, or now Israeli scholars, and many prominent people whose voice is credible and it is impactful. And of course, when such kind of work is being done, and of course, in the world, I don't think that Armenia and Azerbaijan or Artsakh conflict are widely known. Of course, people have very limited knowledge about what's happening in this region. And because of that, I think it's quite unfairly easy to direct that understanding and perceptions of the conflict the way, for example, one country wants. And I think that's what happened in reality in the past maybe 2 decades or 2.5 decades. What has been done, I think that's where we failed. I think we failed there. We really failed there. We didn't create the adequate response to that. We thought why we didn't do that. That's a good question too. Let's think of that. Why it didn't happen? And why we discarded these international legal tools, why we discarded international, why we thought that it's not that important. We really thought that way because I was witnessing that when I was working in the government. I was witnessing that as an expert, working with the government and trying to persuade them that this is important, that we need to take it seriously. And of course, I've been receiving a lot of skepticism, a lot of nihilism, that this is not it. We can do we have other tools. We have reputation of our prominent Armenians, for example, that can be used. And yeah, that's important. Of course, that's important. That's vital to have prominent Armenians as Charles Aznavour, of course. They are prominent, they are widely known, respected, and they can make an impact. But that's not enough. That's not enough. And here we failed because we inherited this approach towards international law from Soviet Union. And we inherited the educational legal system from Soviet Union. We never reformed it. And the understanding that we are transferring to the generations of how to think, lawyers, how to react, how to treat these tools, and whether to use international law or not. And international law was fairly, I think, being a part of the Soviet Union, Armenia never needed international law, of course. And we started to need international law when we became independent, but we never realized the value of it until maybe the painful events that harmed us, maybe, and I was a bit late. So we never did that. So we never filled that gap, and the gap was filled by our adversary, and the gap was filled not on our in our interests. And the reaction I think we got after the war, or during the war, or in the course of the armed conflict, that's from the international community, I think there are very direct results of this reality, very direct results. And not complaining or complain. We can complain, of course, but we shouldn't complain. We should think thoroughly. We should look into ourselves to see why it happened and try to fix that. And of course, you cannot be symmetrical in reacting to that. You cannot be symmetrical in doing things because everything is past now. You have to be a bit asymmetrical now. And of course, for Armenia now, triggering this international legal tools, of course, it's hard. It's a very hard task, and we can you can belittle, of course, the impact that the court's having, but I can ask a question for you, maybe a rhetorical question. Let's imagine in a moment that those legal tools, for example, European Court of Human Rights interim measures with regard to individual captives, were not there. Or let's imagine that Armenia never applied to the International Court of Justice and never got the provisional measure order on December 7, 2021. Would the reality be the same? I don't think so. I really don't think so. I truly believe that we might not notice the impact that they're making, but I'm sure that they are making a lot of impact. One example of this impact that I witnessed, or we witnessed with a legal team when we were in The Hague, and we, after the filing of the application instituting proceedings against Azerbaijan based on the Convention on Elimination of All Forms of Racial Discrimination and the request for provisional measures, when the Armenian legal team was presenting the legal arguments to support the request for provisional measures, we, among other things, Armenia also, reminding you, that requested the suspension or termination or suspension of the military trophies park, and considering that this is a very flagrant violation of the CERT, and it is, the philosophy of that park is Armenian hatred or Armenophobia. And what happened during the hearings, and not even during, I think even days before the hearings, one day before, prior to hearings, we got a letter from Azerbaijan, to the courts, which was communicated to us, which was stating that Azerbaijan has removed the mannequins and the helmet, or will be removing the mannequins and helmets from the park. And what happened later on during the hearings, we got the public acknowledgement by the agent of Azerbaijan that yes, they were removed, and a commitment that they will not be exhibited again in the future. This was then paraphrased in the order of the court, where the court noticed that this has taken place, and the court notes that, the agent made this announcement and commitment that those exhibits will not be returned again to the park. I think that's one impact that we are talking about, even before the order. I think it's profound. Although it can be, we can say that, of course, we were not able to repatriate the captives, because although we asked the court to do that, but we had the understanding that the court would reject that request. Because it's a very legal formality, of course, because the court was operating based in the scope of the CERT, which is a very specific convention. And the court actually justified that rejection based on that scope, telling that the repatriation is a matter regulated within the realms of IHL, International Humanitarian Law, the Third Geneva Convention and the Fourth Geneva Convention, but not the CERT, which is a human rights instrument. It's different. So, but still, I think this impact has been made. And of course, although we still continue seeing a lot of rhetoric, Armenophobic rhetoric, a lot of hateful rhetoric coming out of Azerbaijani leadership every day. Of course, we record that. We have also unfortunately witnessed after the order was published, the actions taken by Azerbaijani government to continuing desecration and falsification of Armenian culture monuments. You remember back in February when a working group was created under the auspices of Ministry of Culture of Azerbaijan, which was tasked with the to erase the Armenian inscriptions on the churches and considering them or representing them or falsely presenting them as Albanian or Uri churches, which is completely. I think that this is the complete representation of the continuous disregard of the order and the cert itself, because that's the policy that Azerbaijan has itself. And I think that these legal tools are what impact they're having is tremendous. It's not only that we need to bear in mind that we cannot have immediate results from using these tools. That's not possible because international law doesn't work that way, unfortunately. And today, given the geopolitical situation that is going on today in the world, it's even making even more difficult to enforce a lot of decisions. Because, for example, if you can imagine, one of the toolkits of enforcement or enforcement of the order of the court of the ICJ is the Security Council, but no one can imagine that Security Council can make any decisions today. No, it's not possible. Even on that matter, even before the war in Ukraine, that was not a possibility. But even after that war, it's even more unrealistic to expect that. But what it brings to Armenia, what it brings to our country when we use this kind of tools, it brings a lot of important, a lot of value. First of all, you are making your voice heard as a sovereign state, and you're re-emphasizing your sovereignty. You're voicing your concerns, you're voicing your grievances, and you're acting as a sovereign member of an international community. You are making your position clear. That's very important too. You're making your position clear. You're making your position very understandable for the international community, putting it into international legal language. You are bringing evidence and evidential measures, and of course, using that tools and influencing those tools are important, but we also know that this in times of this digitalized work and impact oriented world is it's a bit risky, of course, that the courts, you never know which way the courts will go, but of course this is still this is also in our hands. It's in our hands because we have the ability, I think the intellectual ability as the Armenian network nation to make an impact, not only inside the court, but also outside the court. Because making an impact, making the change of the perception outside the court will inevitably impact the decisions of the courts in the end of the day. And I'm not telling to manipulate the international attention, but I'm just telling to attack or to fight the manipulations that is happening today. Because you are by presenting this real story or the story that is happening on the ground, what's happening on the ground, that's important. Because otherwise you're losing the battle. We're losing the battle. So I think those are the main remarks that I have for today. But I'm not going to bore the audience anymore because I know that maybe it will be better to reserve a lot of discussion for the Q&A session. And I try to present the perspective that I'm getting while I'm doing the work. Because while I do the work, while I represent Armenia's interests in international courts, work with the courts, and try to enforce the court's orders and decisions, we see a lot of things. We see a lot of practice, and you see in real world how it happens, why it happens, and why it doesn't happen, and what's wrong with that. So that gives a lot of perspective for us also to think, and what needs to be done to make it more effective, what needs to be done to pursue this path further. because I truly believe that the foreign policy of Armenia now should be highly oriented and highly based on the implementing and speaking the language of international law. That will make it more justified, and that will make it more grounded, and that will make it more understandable and perceivable by other nations and members of the international community. It's a long road, but I think it's we need to go through that road to make some results. And I think concluding, I think I'll stop here. Concluding, I just want once again to thank the organizers of this event. I'm truly grateful for all the work that you have done. I think this is important that we keep this kind of events open, and also I'm also very happy to see a lot of foreign scholars participating in this event. That makes it much more richer. Thank you for that. And I hope that we can be able to continue the discussions throughout this time and make it more periodical as possible. Thank you for your attention. Thank you.
Thank you for that. That was wonderful. We have a lot of questions, and so I'm going to do my best to get through them. I'm actually going to use this mic. Okay, first one is, what role can the international press play in amplifying the truths about the Armenian case to the international court?
Yeah, I think international media can play a crucial role, but I think before that, a lot of work needs to be done by the country itself or by us, because we need to maybe present or put the right emphasis on when presenting the stories, when transferring the stories to the international media. But I think international media also can have a lot of impact in creating the right perceptions in right countries, because that also creates a lot of input. And it's not only a matter of international media, but also the scholarly publications that are being published by different authors, especially. We have a very widespread experience in the past years that many blogs, international legal blogs, are being used to publish very short nuggets or short analysis of very specific issues. And that happens quite often. And one of these blogs is Opinion Juris, for example. And I think those platforms sometimes are being abused. And being abused, this platform so creates a lot of impact on judges. I can say that because I know that. And of course, many judges, for example, in the European Court of Human Rights, they may read the articles and piece published on that blog. And if that piece is one-sided and very biased, which is the case, usually, that can impact the decision. So that's one thing that we need to work on too, because that's really important to make the voice heard, and to make the voice heard also to the right audience and in the right angle.
You spoke earlier about how Azerbaijan is preparing reports and scholars are assisting, and they have been working on this. Segueing from this conversation about the blogs, how can scholars, attendees, panelists who are interested in cooperating and potentially providing reports, or maybe in assisting in these blogs, how can they work with the Armenian government or your office?
I don't think that's a good idea for the scholars to work with the Armenian government. I truly believe that I don't want to do the same thing as Azerbaijan does, because that's not right. That's very and that's happening, and I think that's quite manipulative. And what is important? It's important to have impartial voice heard, impartial analysis of issues to be heard, because otherwise it's not possible to fight this stream. That's what I think should be the case.
On a different subject, in some of our panels, we've discussed the POWs that are still in captivity, along with the MIA, or in fact, the unacknowledged who are held in captivity. What avenues exist to raise the voice for those families and seek legal remedies, if any, to assist in their repatriation?
That's a difficult question, because we have used all of the available toolkit, international law, to raise the issue of captives, ethnic Armenian captives, POW, civilian, doesn't matter. And we have requested the European Court of Human Rights to grant the repatriation, which didn't happen. We knew that it was not going to happen, because the interim measure scope, or the scope that the court grants interim measure, is quite narrow. It grants relating to the risk of irreparable harm of Article 2 and 3, right to life and freedom from torture and inhuman treatment. And we tried again doing the repatriation request for the ICJ when we were operating under the Convention on the Elimination of All Forms of Racial Discrimination. And a minute ago, I described why the court rejected that. But there are other avenues under the UN auspices, which is being used, I know, by individual families of not only the captives, but also the unidentified missing persons too. The working groups of enforced disappearances, for example, under the auspices of the UN, which is being, I know that the individuals have been applying through that working group. And but the problem with those working groups and mechanisms are those are quite limited, because they do the similar task of the work. What they do, they get the request and they communicate to the Azerbaijani government. And I don't think that the feedback and reactions that the Azerbaijani government will give will be different from those which they give through the European Court of Human Rights, for example. That's the thing. But I'm not saying that we should stop, but I think we should continue searching for avenues. Maybe I think the best way is the political pressure. That's the best way to operate at this point, because the legal toolkits have been created already to preserve the security and the life of people who are of Armenian ethnicity, which are under the authority of Azerbaijani agents.
Thank you. What can the diaspora and legal professionals do to assist in any of these processes?
We are, I think, what diaspora is already doing is quite helpful. I think this conference is very bright representation of the fact. I think that's important. We need to create this kind of platforms, continue creating this kind of platforms for dialogue and for discussing important topics and issues, because when we close up and we continue working and we get lost in the routine, that's very harmful for the case too, because you lose the sight of the big picture. And this kind of discussions, this kind of involvement of the diaspora and other professionals helps us to also to conduct some reflections. And those reflections are really useful for us to search the new avenues or have new bright ideas. Because otherwise, I think that what's happening is quite useful, and the government also is trying to be inclusive in that terms too, including the diaspora representation in the work conducted to present Armenia's interests. And I think we do have a lot of huge intellectual resource in the diaspora, which we need to be mindful of first, and we need to think the most effective ways of using that, and we are. Thank you.
There's tons of amazing questions, and this is a very important conversation. One of the next ones, if I can ask, 2 to 3 examples of some of the violations you have noticed of the provisional measures by Azerbaijan against the ICJ ruling?
There are many, but unfortunately, we are collecting, recording the instances when, for example, the president of Azerbaijan is using hateful, insightful rhetoric in his statements and speech, which unfortunately happens after the orders. Although at some point after the adoption of the order, we noticed some decline, but again, I think a month later or sometime later, we again received a lot of reports in the news when Aliyev was using against hateful rhetoric, insulting Armenian nation, ethnic Armenians. That has been a lot. And the other example is I just brought a couple of minutes ago with regard to the working group created by Azerbaijani Ministry of Culture regard to the erasing the Armenian scripts on the cultural heritage sites. That's also a breach of the order, and many more. There are more. We are recording those. We have been communicating the evidentiary materials to Azerbaijan first of all, trying to get some justifications. Unfortunately, we didn't get any even close to satisfactory justification. I think we just got a very ignorant response from Azerbaijani. Then we had to escalate that to the court. We did. And there has been some communication going on with the court and have been presenting those evidentiary materials. And we also have the recent incident, by the way, I mean a couple of months ago in March, when we had the gas supply suspensions in Artsakh. And we had the civilians being targeted in Artsakh again. We had the intimidation and threatening of the civilian population using the loudspeakers. That's also a clear violation of the order, because that's nothing more than that. We have presented those evidentiary materials to the court's attention, and what we're asking the court now, to, because according to very recent amendments to the court's procedures, there is the possibility of creating a 3 judges committee to monitor the implementation of the provisional measures. We have asked for that. We'll see. We hope that we'll get some reactions soon.
Question: how could a favorable decision by the ICJ help the remedial secession case?
In reality, I think that's it's a very good question. In reality, that's let's put it in a more broader terms. That's quite evident that we at this very early stage of the proceedings before the court, when Armenia raised this issue of racial discrimination, and this I want to create some background, and I'll come to the answer to your question, because the obligation instituting proceedings before the court and the request for provisional measures are based on the evidentiary materials of the continuous racial discriminatory policies by Azerbaijan over the past decades. If you go back to the history, even the Soviet times, even you go back to the beginning of the 20th century, you had that animosity existing before then. Like in the beginning of 20th century, you had Armenian pogroms too. Then you had them being repeated after the collapse of the Soviet Union in Baku, in Sumgait, and elsewhere. Unfortunately, you had that animosity also being visible also throughout the Soviet times, because there have been some very flagrant incidents of separate crimes being committed by ethnic-hatred motives. There are some examples on that. And you had also this long-standing policy of Azerbaijan, Soviet Azerbaijan back then. It was, I think, Heydar Aliyev, who was conducting a very concerted and organized policies of creating new Azerbaijani villages, and that was targeted at decreasing the percentage of the Armenian population in Artsakh, which, if you compare to like just the demographics of at the beginning of the 20th century, and then when the USSR collapsed, you had, I think in the beginning, you had close to 90% of Armenians living there, and then close to the end of 80s, you had 73 or something. And you had this being continued, of course, when Ilham Aliyev came to power, he's amplified it. made it to the institutional level because you had this institutional hatred. We remember the Safarov incident when in Budapest an Armenian officer was axed, and those examples, what they are representing, those examples are representing a very deep-rooted animosity, which is happening. You have this, by the way, the racial animosity and racial hatred is the root cause of the many war crimes and grave breaches of Geneva Conventions, what are happening. And what you are seeing, what we were witnessing during the 44-day war, the beheadings or the executions are quite representative of that hatred. And I think those, and that means, what that means that the ethnically majoritarily Armenian populated region, or Artsakh, cannot be a part of Azerbaijan. That's I think that's gonna mean an ethnic cleansing in reality, which should not happen. I think that's where it comes, and I think that's why this case, and I think it's so important for that cause too, because that's directly connected to that, very directly. And I think that, and if you look into the legal justifications for remedial cessation, or if you look into the legal justifications for external self-determination, if you look into the Kosovo's advisory opinion, I'm sure that you remember, and during the Kosovo advisory proceedings, you had also different countries presenting their legal positions with regard to external self-determination, or back then different countries used different terminology. The UK used remedial self-determination, for example. I think Russians also were the ones also submitted that legal justification for the existence of that right too. Germany was one of among them, and France, I think, and most of them used the idea, or recognized the idea of existence of right to remedial cessation, or right to remedial self-determination, when you have the life of a group, a nation, threatened. I think you had also the similar the threat to existence criterion used by the Supreme Court of Canada in Quebec case. So where like this all, if you create this, collect this puzzle, I think it becomes more than evident.
I wish we could go on, but we have a conference. So thank you so much for your time.
Thank you.